Hi, and welcome to Beasley Boorman Lawyers. Today, we are going to look at drink driving offences in New South Wales.
Hi guys, welcome to Beasley Boorman Lawyers. My name is Josh Boorman. I'm a DUI specialist. Today, I appeared at Newtown Local Court on a Middle Range PCA or Middle Range drink driving offence for a client of mine. Now, this offence occurred in July, late July this year. My client was travelling down to Canberra from Sydney, so he was on a fairly lengthy trip down to Canberra when he was pulled over by a highway patrol for a speeding offence. It was 11:30 in the morning, and the highway patrol officer decided to give my client a breath test, which proved to be positive, and upon later testing, he recorded a blood alcohol reading of 0.107. So that was very well into the mid-range category, given the fact that the middle range category is between 0.08 and 0.150. So he was smack bang in that middle range category. And it was a next day offence because basically he still had a presence of alcohol in his system from the drinks that he had consumed the night before. As I explained to the magistrate, in relation to my client's drinking the night before, he had gotten home from his work duties quite late at night at about 9 p.m. He hadn't had much to eat or drink throughout the day. He began drinking straight away on an empty stomach, and he ended up consuming 2 bottles of red wine between about 9 p.m. at night and 1:30 in the morning. He then retired to bed at about 2 a.m., got up at about 8:30, 9 a.m. and set off on his trip down to Canberra, his lengthy drive down to Canberra. And as I've mentioned, pulled over because of a speeding offence. And I did have to contend with the fact that his manner of driving was the main factor in which brought him to the police attention. If it wasn't for the fact that he was speeding, he probably wouldn't have been breath tested. So the speeding offence was seen as an aggravating feature to the drink driving offence. And an aggravating feature is an issue or a feature of the manner or facts of how the drink driving incident occurred, which could increase the risk of injury, hurt, or an accident to other people on the road. So that was one issue that the had to be contended with before the court. Of course, my client did obtain a small discount since this was an early plea of guilty. Initially, however, because this offence occurred on the Hume Highway down near Goulburn on my client's way to Canberra, the matter was listed at Goulburn Local Court about 6 to 8 weeks ago. So what we did, my client lives in Sydney, we were able to engage a local solicitor down in Goulburn who was able to appear at the Goulburn Local Court and act as an agent for us. They were able to enter a plea of guilty on our client's behalf and very easily able to have the file transferred up to a Sydney court, and we had it transferred to Newtown Local Court because that was close to where my client lives. So we were able to do that. It was able to prevent a huge amount of inconvenience of our client having to travel down to Goulburn Local Court to have this matter heard down there. In relation to our client, he's a father, he's married, he holds a steady job, and part of his job does involve a significant amount of travelling, and that can be to all over the state, to various rural areas, especially given the fact that he is involved in the horse racing industry. So he needs to attend to a number of these horse racing courses, and on the date of the offence where this occurred, he was on his way to Canberra horse racing course. So we were also able to put across to the magistrate today that our client does heavily rely upon his licence in order to carry out his work, and advise the court that my client travels up to 40 to 50,000 kilometres a year just for his work, and since losing his licence, it has significantly impacted on his ability to get out to the various race courses in the rural and regional areas of New South Wales. So this was a factor that was taken on board, but the big uphill battle and the big problem that my client did have was the fact that he was considered a repeat offender. He had a middle range PCA offence only 2 years ago in 2003, and then he also had another middle range PCA offence back in 2007. So really it was his third drink driving offence before the court today, and that was a big issue that we were up against in order to try and get our client a positive or a good result. One big factor that I was able to put before the court today was the fact that my client openly admits that from time to time he does binge drink, he works late, he travels long hours, he gets home at a late hour of night and tends to drink quite late. Just like on this occasion, he didn't diligently assess whether he still had alcohol in his system. So I did try to put across to the magistrate that it wasn't an issue where my client went out recklessly drinking and just got into his car to drive home. It was a matter where he had woken up the next day, he didn't believe there was alcohol still in his system, but of course there still was that presence of alcohol in his system which hadn't fully metabolized. So this was an issue that was taken on board. Another significant issue that was taken into regard was the fact that he went along and did the traffic offenders program, the fully approved course, approved by the court system, and we're able to help our client with a letter of apology put to the court outlining some of the significant lessons that he was able to take away from having participated in this traffic offenders program. This was all well received by the magistrate, and at the end of the day, the magistrate decided to reduce his disqualification down to a minimum period of 6 months, and that was backdated to the date that the actual offence occurred. So he's already been off the road for approximately 3 months. He has about another 3 months to serve. However, due to new mandatory interlock laws which came into effect as of 1st of February 2015, they were applied, and my client was aware that once he did get his licence back after that 6 months disqualification had expired, he would need to drive with an alcohol interlock device in his car. Now, the minimum for this type of repeat offending for a middle range PCA, the minimum period of interlock device is 24 months. Due to the fact that my client had, to be quite honest, a terrible traffic history and record as a repeat offender, the magistrate sought to put my client to a period of 30 months with having the alcohol interlock device in his car. And the other thing that the magistrate sought to do was put my client on a good behaviour bond under Section 9. So basically, this was for a period of 12 months. If my client reoffends anywhere within that 12-month period from the date of court, then he can be called back before the court and resentenced on this matter and whatever other additional charges have brought about that breach of good behaviour bond. So it will be for the next 12 months a bit of a notice, a bond hanging over his head that he needs to be of good behaviour. He was fined $1,200 and he was convicted. However, given the fact it was his third time drink driving, my client was extremely happy with the result. There was a very strong possibility that he could have received a suspended jail sentence or some hours of community service. However, that was not dealt with by the magistrate today. Instead, he decided to go for the lower penalty of a standard good behaviour bond under Section 9. So a happy client out of this matter, and I believe we got a good and fair hearing, and it was good to see that my client will be able to get back on with his life after he's served out the 6 month disqualification period. Guys, this is just one offence that we dealt with today. Of course, every drink driving matter has its own set of facts and circumstances and different features that come about the case. And of course, no one DUI is the same as the other. So courts will look at all the different issues involved and deal with them on a case-by-case basis. But certainly, if you have found yourself where if you've been charged with a drink driving or an alcohol-related traffic offence or a drug driving offence or any sort of traffic matter, rest assured we do specialise in this area of law in New South Wales, and you can give myself a call, Josh Boorman. I'm happy to have a free first telephone consult with you to discuss your options and what you can expect if you have been charged with such an offence. Or also go along to our website if you haven't already seen it, beasleyboorman.com.au. There's plenty of information, blog posts, videos, information relating to laws, defences that we do discuss there on our website, and you can make yourself a favour with the position that you are actually in if you have been charged. And then if you are looking for some quality legal representation, like I said, give me a call on 02 9283 8622. I'm happy to have a free first telephone consult with you. Thanks for tuning in, guys.